One.
Okay, this is a call to order of a special meeting of the Bridgeport Board of Education. Today is Monday, May 3rd, 2021, and the time is 6:44 p.m. Mr. Secretary, would you call the roll?
Yes, John Weldon,
Present.
Bobby Brown,
Present.
Sybil Allen,
Present.
Albert Benahan,
Present.
Jessica Martinez, Joseph Sokolovic,
Present.
Chris Taylor,
Present.
Sosimo Fabian,
Present.
myself, Joseph Lombard, present.
Okay. Also present is Floyd Dugas, Attorney Floyd Dugas from Bertram Moses. And we have another attorney here, Attorney Susan Nelson. What firm are you from and who are you representing?
I'm here from Jesmond, Petro, Simone, and Scrignari, and
Okay.
I'm representing the union for Ms. Walker Jones.
Okay.
Thanks.
That is the second item on the agenda. I'm going to ask for a motion to consider item 2 prior to item 1. So consider the Gladys Walker Jones matter prior to anything else. Is there a motion to that effect?
So moved.
So move.
Okay, moved by Mr. Sokolovic. Is there a second?
Second.
Second.
All in favor?
Aye.
Aye.
Opposed? Okay. This is an item that qualifies for executive session. I'm going to defer to Attorney Dugas. Do you need us to go into executive session without Attorney Nelson, or? does she
No,
need-
what I would, first of all, Susan, if I may, on behalf of your client, is it her desire that the discussion take place in executive session or public?
You know, she has not shared that with me, and is she in the room?
I did not see her.
I do not see her.
Okay, not in the waiting room, or,
She is not in the waiting room nor in the room.
okay. I imagine that she would be fine with executive session, but I have not had that conversation with her.
All right, the problem is the employee has a right to know and affirmatively object to it being an executive session. So this gives us two choices. One, either Susan, you could contact her and be able to express her view with a brief recess for a call, or we would proceed in public session, would be my recommendation, Mr. Weldon.
Okay, I'll tell you, maybe you could go do your first agenda item while I try and reach her right now.
Why don't we just press pause for 5 minutes?
Okay,
We'll just, if you, I don't know if you want to go to another room and make a quick phone call or do it right here.
okay. Thank
The
you.
other, the reason why is the other item could be equally lengthy, so.
Okay.
Were you able to reach her, Attorney Nelson?
No, I got her voicemail, so I just sent her a text. Give her, 30 seconds or a minute or so to respond. I thought she would be here.
Okay. All right, well. You want to just wait 30 seconds, see if she responds, and if she doesn't, then we'll follow our advice of counsel.
Yeah, we'll get started in public if we don't hear from her shortly, and if we do, we can always go into executive session at that time.
Okay, yeah, I posed the question to her in my text.
Mr. Chair,
Mhm.
and through you to the attorney, doesn't the client have the right to speak through her attorney as her authorized representative?
That's the thing, is that she hasn't had this conversation with me. And she can't, and Attorney Nelson can't unilaterally speak for her without consulting with her on the matter. So I think that's the issue. It's an ethics question.
Right.
And it's also a FOIA question.
And a FOIA.
Correct. And before we go down the same road that we went down before with the last employee thing in public session, I would caution us not to go into public session as we are going to be discussing somebody's, if we can't affirmatively contact her, is this an emergency situation that has to be cleared up right now, or can we reconvene at a later point with either an affirmative?
Unfortunately, the statute requires a written decision by May 8th. They only give us 15 days under the statute, so we don't have the luxury of being able to reschedule it. So if we don't hear from her, we'll have to proceed in public session, and we'll just have to be as careful as we possibly can.
Tactful.
Yeah, I'm not getting anything from her as of yet.
All right. So this, I believe I asked for this document to be emailed to everyone or put in the portal. Is that what happened?
Yes, sir.
Has everybody read it? If you haven't, be honest. It's a big document. Okay.
And I can certainly,
Attorney
Right.
Dugas, I'm going to ask you to kind of give us a summary.
that's what I was going to do. I think I stepped on Mr. Lombard, though he was speaking.
Oh, I'm sorry, Mr. Lombard.
No, I was just confirming that it was in the portal with the other material.
Okay.
Mr. Taylor has his,
Mr. Taylor has his hand up.
Yes, I just had it was more a social question for Attorney Nelson. I was just curious how Howard Kantrovich is doing.
Oh, he's fine as far as I know.
Is he no longer with the firm?
Well, he's pretty much retired. I'm not sure how official that is or exactly when that happened.
When the coffin is closed, he'll be retired.
Yeah, that's kind of how it's going.
Yeah, that's what I figured.
Generally.
For lawyers in general, that applies.
Yes, true.
All right. Why don't I give an overview, and if Susan, you hear from Ms. Walker-Jones at any point, feel free to interrupt me so we can move into executive session.
I will. I hope that I'm not erring here by not requesting on her behalf that we go into executive session.
I don't think legally you can do that under FOIA.
Yeah.
Without having actual permission or knowledge. So
Yeah.
Unfortunately, I think we're going to have to proceed in public at this point anyway. Okay. Good evening, everyone. We are here to consider the termination of Gladys Walker-Jones. Ms. Walker-Jones was a principal in the school system. As I explained to you, I think in connection with a prior proceeding that we were involved in about a month or so ago, this is not a procedure under the collective bargaining agreement. It is governed by state statute, Connecticut General Statutes 10-151, And it has a very specific process that's laid out in the statute. And I'm going to describe that briefly to you in your role and then get into some of the details, at least to the extent I can get into details or feel comfortable given that this is in public. Under the 151, what's also known as the Teacher Tenure Act, the way that a teacher termination happens is it starts with the superintendent of schools. And the superintendent of schools notifies the employee that termination of his or her contract is under consideration. And by the way, the Teacher Tenure Act applies to both teachers as well as certified administrators below the rank of superintendent. So it applies to a principal as well as it does a teacher. So in this case, initially in May, so almost May 1st, a year ago, Mr. Testani first notified the employee that termination of her contract was under consideration. And for reasons that I won't spend much time on here, Ms. Walker-Jones at that point neglected to request a hearing. And this process sort of went sideways for a while as I debated with Attorney Jesmond, who Susan works with, as to whether that meant she wasn't entitled to a hearing at all or whether we had to do a restart. So long and the short is we did a restart at the beginning of the current school year and got the process going again. So the way the process, the statute works is once Mr. Testani as superintendent notifies the employee that consideration of their contract, termination of their contract is under consideration, the employee then has a choice. And that choice is to either ask for a hearing before the board or a subcommittee of the board or an independent hearing officer. And in this case, the employee requested a hearing before an independent hearing officer. In this case, a gentleman that you can see from the document, Gerald Weiner. Mr. Weiner was a local attorney, practiced in Bridgeport for many years, and is a well-respected hearing officer for these types of hearings, as well as an arbitrator. So what then happens from there, once an independent hearing officer is picked, is we have a number of hearings before the hearing officer. Each side gets to present evidence and testimony, and then the hearing officer ultimately does two things. He makes findings of fact, and he makes a recommendation regarding what to do with the employee. Okay, and because of a Supreme Court decision that actually Ms. Nelson's office, before she was with that office, was involved, Mr. Jesmond was involved. The case went to the Supreme Court, and in that case, the Supreme Court held that you must accept the findings of fact. You have no choice in that, so you don't have to get information and evidence and retry the case. You have to accept the findings of fact as found by the hearing officer, even if Ms. Nelson or myself thought there should have been other findings and the evidence supported it. We sort of were stuck with, or we own the findings of fact made by the hearing officer. What you don't have to do is accept the hearing officer's recommendation. You are free to do what you think is fair and appropriate under the circumstances. Now, in this case, we had multiple days of hearing. There was also extensive medical documentation spanning almost 10 years. And so I'll give you a brief summary of what the evidence found, but certainly you're relying on the findings of fact that were in the document. This situation goes back to, believe it or not, January of 2011. And in January of 2011, the individual involved slipped on some ice and fell. Following that, at that time, she was initially I won't get into any diagnosis, but suffice it to say, she was out of work for a couple of months, a few months, and then she ultimately returned back to work in April of 2011. In 2012, she really did not have any issues. There's some medical records suggesting she continued to have some problems, but she really didn't miss any work. 2013, there was a flare-up of the situation. In 2014, she continued to complain about a number of things, including headaches and dizziness. And then in 2015, so we're now 4 years after the fall, she missed basically the entire month of June of 2015. Then in 2016, she was out from December of 2016 through June of 2017. So essentially almost 7 months she was out of work. During that time period, she was restricted to sedentary work only, and her doctor noted that she continues to struggle despite an array of treatments that she was undergoing. So now this is basically 6 years and change after the original fall. There was what's known as a functional capacity exam in March of 2017. And I should tell you that there is a parallel workers' compensation case going on. But having told you that, I would suggest to you that you can't and should not rely on the fact that there is a workers' compensation case going on. But in case it was a question, I did want to point that out. In any event, there was a lot of this, the medical stuff we rely on came out of the workers' compensation case and subpoenas of doctors' records and so forth. In any event, there was a functional capacity exam done, and that concluded she was unable to work at that time. She couldn't lift, and among other things, she wasn't even able to care for her own grandchildren. Okay, and she had a sedentary work capacity only. In June of 2017, she was sent for an independent medical examination, which is basically the school district's, the city's doctor to evaluate her. And he quote, found it extraordinary that someone would still be having symptoms at that point after more than 6 years, almost 6.5 years from the date of the injury. She returned to work in August of 2017, but because of restrictions, she only returned part-time. Now, keep in mind, we're talking about a school principal. She could only work 4 hours a day. The testimony in this case, including the testimony of the superintendent, was being a school principal is up to a 12-hour job a day. And she was only capable of working 4 hours. So what the school district had to do, and what it agreed to do in the context of the workers' comp case, was to basically hire another part-time, I think it was a retired principal, who basically did half her job for her. So you were effectively paying for 1.5 principals, and that continued for approximately 1.5 years. Okay. She returned to work for a short period of time in January of 2019. And if memory serves correctly, that's when she fell off her chair, sustained additional injuries, and that was the last time she worked for the Bridgeport Public Schools. Okay. Fast forward to October of 2019, her doctor there was a deposition taken of her doctor in the context of the workers' comp case. And among other things, he was asked, do you see her ever being able to do her job as a principal? And he said, and I'm paraphrasing, but he said, I don't see that it's likely. Okay. Then we come around to May 1st, 2020. The superintendent sends the first notification that he's considering termination of employment. Now, you can read into this what you want and what I think the hearing officer read into it, but she goes back to her doctor and she sees him a few weeks later, towards the end of May. And despite the fact of essentially 10 years of her complaining, I can't do the job, her missing a significant amount of time, which I'll summarize in a second, her doctor suddenly says, oh, she can work, after the superintendent sends a notification. Now, it's not an unequivocal she can work. It's, well, she can work with restrictions. And it was unclear exactly what those restrictions were, but suffice it to say, she couldn't lift. She wouldn't be able to break up a fight between kids. She wouldn't be able to restrain a child. And there were other, and it was during the hearing, by the way, her doctor testified, and I inquired about some of those restrictions, and among other things, he did not think she would be able to, in the case of a fire, aid in evacuating kids from the school. God forbid there was a more serious incident in the school. She would likely not be able to assist with those duties. And importantly, when I asked him point blank about his change in his all of a sudden she can work, he admitted that he couldn't say that with any certainty that we wouldn't see the same attendance issues that we had seen since 2011. Now, just to summarize, I've quickly gone through that, but just to summarize, and it's in the findings of fact from the hearing officer, you paid her for 194 days of complete absence. You also paid her 406 days of part-time, when she could only work part-time, and you had to pay somebody else to help her do her job. In all, she missed almost 400 full and partial days during this period of time, or as the hearing officer noted, during the last 10 years, she has averaged 44 days of absence per year. Yes, there were some years where there were little or no absences, but in many years where there was more. Again, I don't want to get into the underlying medical condition, but what I will tell you is that according to her doctor, she is not cured, and she will likely not be cured. She will continue to have the underlying medical issues in all likelihood for the rest of her life. And again, there are no guarantees that it will not prohibit her from the types of absentee that we've talked about in this case. I do want to point out one other thing, is there's also testimony, there's findings of fact. She's fallen no less than 3 times. She's had some balance issues. And aside from that initial fall in 2011, which was ice related, since then she's had additional falls, which have added to the situation that brings us here. So as you saw, based upon the findings of fact, the hearing officer made a determination that termination was appropriate. And furthermore, he specifically recommended termination given the facts. Now, you all know as well, if not better than I do, what the job of principal entails. Mr. Testani testified, it's not an easy job. It is a 12-hour a day, up to 12-hour a day job. You need to be visible in the building. You need to be mobile. You need to go into classrooms to evaluate teachers. And unfortunately, things happen. Kids get into a fight, you've got to restrain children, and on balance, the medical evidence indicates these are things that the employee, unfortunately, can't do in this situation. As I've noted, this has been going on for 10 years. I have to tell you, I've seen some cases in my career, 3, 4 years, I've never quite seen anything go on as long as this case. And, you know, it would be one thing if we had an x-ray or an operation we could point to that said this employee is completely healed and this will not continue. But her own doctor indicated that, you know, that's likely not the case. And so this situation will continue. You need to have a building principal who's going to be there, not just to break up the fights, but to make sure that the kids are behaving, to be the role model in the building, to make sure the teachers are towing the line and do what they want to do, to make sure the culture in the building is where it should be. And you can't do that on a part-time basis. You can't do that if you can't get up out of your office and go down the hall to do it. So based upon all of that, I encourage you not only to, of course, adopt the findings of fact as you must and the conclusions that were reached, but also the recommendation of the hearing officer that the district has been more than patient with this individual, more than accommodating, and, you know, unfortunately, it's time, she can't do the job anymore. It's time to move on so that you can permanently fill her spot and the district can move forward. So at this point in time, I would turn it over to Susan for her response. Susan, you're muted.
Okay. Well, I wasn't anticipating having
Okay,
to.
hang on. If anyone is not talking, please mute yourself. Are you able to do that, Michael? Okay. Go ahead, Ms. Nelson.
Yes, I mean, the findings of fact are what they are. And I did write 2 briefs relative to this case. I wasn't exactly planning on presenting them to you guys today. But I would point out that Ms. Walker-Jones had a number of years before her first injury in 2011, where she was here all the time. I mean, she was at work every day. When she was working, she was working. And I wouldn't want you to have the impression that she was trying to take advantage of the system in some way. I think to the extent that the hearing officer found that she is disabled, that, you know, she may well be disabled. What we were initially looking for was an opportunity for her to try to return to work because she was improved, not trying to guarantee that she would be successful in doing that. What I actually hope may be the next step for her, although I frankly admit I'm not familiar with the retirement system yet, but maybe there is something that she can apply for in connection with being disabled at this point. We're not handling her workers' comp claim, so I have no information on where that stands. But that's basically where the union was initially coming from, is yes, she has in fact had some serious medical issues over the years. You know, not her fault. She's unfortunately been struggling with this. But if she can't have an opportunity to attempt to return, we don't feel like she should be terminated in punishment. It's just an unfortunate situation.
Okay, thank you, Attorney Nelson. I'm just going to state for the record, this has no bearing on her performance. This is not about punishment. No one here has said that Ms. Walker-Jones has been abusive of any resources that have been made available to her through the course of all of this. As I read the hearing officer's write-up, This, to me, is a matter of you need to do certain things to hold this type of position. And if you simply can't physically do that, then a separation is in order. And, she may find other career opportunities with not the same demands. She may find other alternatives in the form of disability resources. I don't know. I'm not postulating on that, but those opportunities are always possible. So I just wanted to state that for the record. This is nothing against Ms. Walker-Jones. It's not punitive, and we're not saying anything about her integrity or her character being anything less than honorable. Okay?
Thank you. Understood.
So I'm going to open the floor up. I see 3 hands up. The first one I saw was Mr. Benahan, so I will go to him first.
Thank you, Mr. Chair. I believe that Mr. Testani did the protocol and contact Ms. Jones and very well the way it's supposed to be. But I have a question, I believe Mr. Floyd that can answer me, or Mr. Testani. How did she got hurt, and how much money that BOE has spent with the 194 days or 406 days you report us?
I can answer. On the half days, the district spent close to $150,000 to supplement with a part-time retiree to cover the remaining part of the day that she could not work.
And I'd love to know how she got hurt, please.
As Mr. Dugas said, she fell a few times in the district over the years.
Okay, thank you. No more question, Mr. Chair.
Okay. Dr. Fabian,
I was next, John.
you were next? Okay.
Yes, sir.
Taylor?
Yes, I'll direct these to Attorney Dugas, if I may. And I have a series of them, and I'll be quick. Attorney Dugas, was she originally hurt on Bridgeport Board of Education property or city property, something controlled by BOE?
Yes, sir.
Okay. Second question, had Aresta Johnson taken any action with Ms. Walker-Jones?
I honestly can't answer that. I'm not aware of it, no.
No? Okay. And I apologize. That's Dr. Aresta Johnson. I apologize. Does Ms. Walker-Jones have a doctor's release returning her to full duty?
She
No.
has a doctor's note that says she can return subject to restrictions.
Okay. So she does not have a doctor's release saying that she could return to full active duty?
Without restriction, no.
Okay. How long has she been with the Bridgeport Board of Education?
It's in the
I believe the
ballpark.
paperwork said 1997.
That sounds about right. I was going to say just over 20 years.
And in that 20-year period, was she an exemplary employee? I mean, was she a good employee? I mean,
Honestly, I did not look at her evaluations because we were looking at the medical situation and the absentees.
that's where I have some concern. I have disabilities, and people quit on me in life, so I don't quit on people with disabilities. So she was an exemplary employee, and she had some medical issues that could be overcome, but it doesn't look as though they were. I think that's a monumental pivot point for me in any decision, pending her past performance. I would like to hear from Ms. Walker-Jones herself. Me personally, I am not prepared to terminate. Maybe back with a probationary period if the doctor says she can return to full duty. But because a woman got hurt on our property, a teacher got hurt, or a principal, I apologize, got hurt on our property, and it's taken a long time and it's taken her toll. It sounds to me from the hearing officer's opinion that it was bled for everything it was worth. It took an awful long time to get to this point. And I mean, listen, if she's well enough to return, if she could produce a doctor's note that says she could return to full active duty, I personally see no reason to terminate. I don't know how my colleagues feel about it, but till hearing from her, I would not terminate till I heard from her, as we extended the last person from Bassick High School we had an issue with. I know this is different, but I like to be fair and equitable. Thank you. That's all I have, sir.
Okay. Dr. Fabian?
I was just wondering if the district has a benefits coordinator such that this particular principal can be educated as to whether or not she can avail herself of a disability pension, or what benefits might be available out there. Hearing Attorney Nelson, it suggests to me that her client might be amenable to understanding her current situation, and I would rather be guided by Attorney Nelson's kind of perspective that, look, I understand that it might be time to part ways, but I would like to do it in a way that is demonstrate our gratitude for the many years of good service that she did give us. And after all, she did, get injured while on the job. So I would like to have a better understanding as to whether we have a benefits coordinator who could educate this principal. And two, if there are alternatives where we can find a resolution, an amicable resolution, such that Ms. Nelson is shown, the requisite amount of gratitude for the years that she did give us. Something that doesn't make it seem as if we are parting ways with her, with even as much as a whiff of, punishment.
If just two things, if I can respond, I'm sure that Ms. Ultra Dixon's office and the benefit folks can get her in touch with the appropriate person at the state. There is a disability component of the teacher retirement pension, so I'm sure they can connect her to whoever they need to do. And just to your last point, there were multiple times I reached out to then Attorney Jesmond, trying to reach a resolution, and it was not satisfactory to Ms. Walker-Jones. So we did try.
And then, look, the shortcomings of, I have a question. I just don't, I don't know the appropriateness of asking the question in a public forum.
Okay.
Mr. Chair, may I?
You have
Or
something
the
to add?
conversation would disclose.
Hang on, Mr. Testani.
Say that again.
Dr.
Mr.
Fabian,
Testani had something to add.
Well, I just missed, I know Dr. Fabian broke up and then I was going to add some.
Okay. So is there something, are you not certain how to phrase your question, Dr. Fabian, or are you willing to say what it's kind of related to?
looks like he's frozen.
He's frozen.
You're frozen, Dr. Fabian.
All right, I'll just add, as Attorney Dugas mentioned, we do have a benefits person that can advise. The collective bargaining unit also has support for its members. Knowing this case on both ends, there's been numerous attempts over the years to try to counsel and to advise the individual. And as Attorney Dugas mentioned, the numerous attempts to counsel and to advise the individual through the collective bargaining unit fell on deaf ears and were refused. We got to this point after multiple attempts from the collective bargaining unit and from the district to try to come up with a solution that would best serve the individual, yet it was refused at every turn over the years. We were left with no other choice but separation. And to that avail, we've made other attempts to try to separate on a very amicable and I would say transitioning approach, again, to no avail. There was no option, as Mr. Taylor tried to mention, there was no option given the letter provided for return that we could put this individual in a situation that would not be in harm's way. The restrictions that were placed in the letter were beyond any normal accommodations. They were unrealistic and not one that any job function except somebody sitting at a computer all day could even accomplish. So I don't know what else to say. We went to an arbitrator, went to a hearing officer, presented both sides, and these were the findings.
John, can we hear from Attorney Nelson as to the possibility of her client being open to a separation? I mean, I read I heard what she said. It seemed to me like her client is there now. I just, kind of want to see if that's what she was intimating when she spoke as to, this not being punitive or not coming across as being punitive.
Well, and I think we accomplished that, which clearly stated at the beginning of this discussion. This is simply about the physical ability of the employee to do the work that's expected.
That's not my issue. My issue is exploring whether the employee now, given where we are procedurally, whether the employee is open to entering into agreement to bring about a separation with the district. That's my question.
Okay, let's ask Attorney Nelson and what her thoughts are of that.
Well, I don't know, but my thoughts are that she should be. I would certainly recommend that she avail herself at this point of her any entitlement to her retirement under disability. I'm not yet familiar with the disability retirement process, so I don't know if there's timing involved, if she needs to do that before or after a determination is made. I really don't know. I can say that I would certainly recommend that to her, but I haven't had that conversation recently, so I don't know for sure.
And I don't know, did you hear everything that Mr. Testani said before you got back on?
Well, I think I caught the gist of it, which is all the good faith efforts that were made to try to bring about.
No. He prior to saying that said that the HR director's office does have a benefits administrator who can guide Ms. Walker-Jones through any mechanisms that she may try to utilize for disability. He specifically noted that there is a disability component to the pension, and the benefits person could guide her in that direction.
Well, and again, the collective bargaining unit has tried on multiple occasions. I personally, at one time, tried. I know as recently as these proceedings, they have tried to advise and guide the individual, but again, not receiving the advice well. And for the attorney, and I know, I don't know Susan Nelson, Attorney Nelson, but I know Attorney Jesmond. I worked closely with him for years. He is not a slouch. He has advised and done his best here, but you could only do so much if the individual is not going to take the advice of the counsel. This is where you end up.
Okay. Mr. Kolovic, you got your hand up?
Yes, I got several questions. Maybe we can handle them one by one. Was the initial claim of her falling in ice ever attempted to be controverted?
You're not speaking very loudly. Can you?
Okay, I got several
Better.
questions. I'll give them to you one at a time.
Do you want me to answer that one first before you move
Yeah,
on?
Yes, you heard.
So the short answer is yes. It was the claim was denied. The city, the board's independent medical examiner didn't believe the diagnosis, and the fact that 10 years later the workers' comp case is still going on says that it's very much in controversy.
And did it go to a second level, and was it affirmed?
It's still pending.
It's still pending 10 years later?
Yes, sir.
Initial accident? How is she being paid right now? Is she being paid from the Workman's Compensation Fund, or is she being paid out of district funds?
She was being paid out of the Workers' Compensation Fund. And remember, in a public sector entity, it is the board that's paying it or the city that's paying it. But then when we started this proceeding, we put her back on regular pay, so you are paying her now.
So for the last 9-something years, she's being paid out of workman compensation for a claim that's being controverted?
Well, no, not that entire time period. It's been a combination of workers' comp, pay from the district.
When she returns, when the days that she was back, I assume.
Yes, sir.
Okay, but we're not controverting the fact that she fell on the ice. That did in fact happen, since we're not questioning her integrity.
To the best of my knowledge, correct.
And the next injury, about I think it was 6 years later, she fell off a chair. Was that ever a challenge that she fell off a chair?
I believe it was, yes.
And do we believe she fell off a chair?
I can't speak for the folks who are handling the workers' comp case, but I believe that is a controversy, yes.
Okay. Okay. I would like to talk a little bit. I think this might be more of Mr. Testani's venue. In the job description, every single limitation that she seems to have seems to be physical. For instance, we didn't mention it here, but in documents we got, it says crawling, lifting, climbing, etc., etc. Can you give me an instance where a principal would have to crawl?
No, the letter gave specific restrictions, like, I don't know if Attorney Dugas, can I mention what the letter had mentioned in terms of restrictions?
Sure, yeah.
Must be close to a bathroom at all times. Must take frequent breaks. I'm trying to think of a few of the others that you can't be near a bathroom all the time. Number one, if you're out evaluating teachers, you can't take frequent breaks. There could be times she would need to take off to rest because she may not be able to work every day. Again, she may have to take some abbreviated days. These were things that on the collective bargaining side, I had warned the district from that angle, that this is just a setup for failure. If she cannot return with a clean bill of health, the likelihood of another incident occurring, which did as she was nearing the end of her sick days to compensate for the workman's comp time, another incident occurred. We are just setting ourselves up for further liability if we just allow and disregard the advice of her own doctor. It's not our doctor, it's her doctor saying that he has questions now. Once he learned of what the job entails, he's reversed course as well. So I don't know, what we're looking at if we have her own doctor questioning her return. She has an avenue. She just needs to be able to take it. We also had, during the time when 16 months she was out of work, claiming that she had physical ailments that prohibited her. We also have photographs taken from a private investigator that contradicted the claims as well. So there's a lot that went into this.
And how come we weren't presented? Again, and you're asking us to terminate somebody now. These pictures and photos, and none of this was included as part of our packet, and we're hearing this. I don't know if anybody else ever heard this part of the claim, but
I'm just gonna say, with we have 3 days of hearings in front of a hearing officer. The whole 19 pages here of findings have been presented. I don't know what else we would need to do I mean,
I think we need, I think we're getting a little off track here. I think the question ultimately is, can this individual do the job and the tasks that are required of it.
Okay, yeah,
And if the answer is no, that doesn't mean there aren't other options for her. But for the needs of the district and for her own safety, the problems that have been indicated through the course of the hearing, it seems like this is not a relationship that can continue anymore. And that's really what we're talking about.
And just to add to that, she chose going in front of the hearing officer, not the Board of Ed. So for the Board of Ed now to try to step in after she chose which venue she wanted to hear the case, I think is just counterproductive to the protect. I mean, we're here to protect the Board of Ed and the liability. We can't just get a do-over when you didn't like the venue that you chose the first time.
Absolutely, but this is here for a reason. At this point, I'm not trying to challenge anything. I'm gathering information in order to make my decision. And I would like to continue gathering my information based on the documents in front of us. And I don't believe this will be causing any controversy. I would like to read from page 7 of the document we got. It has to do with the functional capacity evaluation that was performed. And it says she was found to be unable to perform the lifting, carrying, walking, climbing, stooping, squatting, kneeling, crawling, and floor level reaching, which was required for her job. Now, to me, that's saying anybody in a wheelchair need not apply for a position of principal in Bridgeport Public Schools because they can't do it because they have physical limitations. Is that the case?
What I would say is if you had all of that, but you had somebody who never missed a day of work, then that's a different conversation. But the problem here is you've had somebody who has missed the equivalent of 2 complete years of work that you've paid them for over a 10-year period. And her doctor is saying, I can't guarantee you that's not going to continue. And the one thing I know about being a principal, you need to be there.
Okay.
I would just add one thing, Mr. Sokolovic. We have a teacher, I'm not going to say his name, in one of our high schools who is paralyzed from the neck down, has been paralyzed for the last 20 some odd years, and has missed probably a total of 10 work days in those 20 some odd years, comes there every single day, does the job, is beloved, and does an exceptional job. So I don't want you to think, or I don't want it to be misconstrued that we would do this to someone in a wheelchair. That is not the case at all.
So would this individual be qualified to be a principal if he so applies, and being unable to break up a fight, being unable to crawl, climb, reach, would he be considered for a principal's position?
I wouldn't be able to answer that question right now.
Well, I sure hope the answer would be yes, because
well,
that would really
here's
get us.
Here's the difference between what I hear Mike saying and Attorney Dugas saying, is that in the case of this individual, this level of disability has illustrated that the individual is unable to consistently perform the work. It's not as if the individual has a level of disability, but despite that, has lived up to the requirements of the job. I think that's the distinction, is that in the past experience with this individual, it's been illustrated that they can't do the job on a full-time basis.
Right, but that's understood. But say this, since I didn't bring them up, but say this teacher in a wheelchair did apply, I would expect us to follow the disability law.
Absolutely.
And provide him with reasonable accommodations in order to perform the job function.
Absolutely.
Now, we're in the same position. Ms. Jones was put in this position, as far as I can see from the documentation, due to 2 accidents she had on our property while in the performance of her duties. And she's not be given the same reasonable
She has been. She has been.
She has
We
been.
have provided.
Now, let me ask another question. Is a teacher particularly married to forgive me, a principal particularly married to the building she teaches in? For instance, does a Bassick High School principal always have to teach at Bassick, or is there?
No, we moved this individual. We offered to move the individual. The issue is, Mr. Sokolovic, every attempt we've made has been turned down unless it is the exact wants and needs of the individual. We've made every attempt. I mean, like I said, I was on the opposite end trying to negotiate something suitable. But when someone doesn't want to listen to the advice and the guidance of everyone involved, this is where you end up.
Can we offer some sort of compromise where maybe she could be, like, we got teachers on special assignment, like a principal on special assignment? Because we've got a lot of backlog of paperwork that somebody who's sitting still can do all day, such as maybe go through our backlog of IEPs or something like that, and just administrative work where we wouldn't have to worry about her evacuating a school or.
So we want to pay somebody to go through paperwork of $140 some odd thousand a year, when if we have the resources to do that, we can hire someone that can fill the needs that the district has.
I don't want to be a district who, with already difficult recruitment problems, showing that an employee injured doing his or her duties will be tossed to the curb without. I mean, how's that going to be for recruitment? She put in maybe a good 10 years beforehand and then hurt herself, and not once but twice in the performance of her duties.
Falling off a chair is not in the performance of your duties, allegedly.
It's climbing. Climbing is listed as one of those things. Climbing, lift. She could have straight up back lifting. She could have. It's falling on the ice. The initial ones.
Yeah, you know.
Because I'm leaning way towards not terminating.
You know, Mr. Testani has already said that over the past 10 years, various accommodations have been provided, and they either weren't enough or they were flat out declined. And so are we to continue throwing accommodation after accommodation after accommodation? At what point, hang on, at what point do we say, you know, we've really done everything we can. It's nothing personal. Your best option at this point is to pursue your disability benefits, but we need to do what's best for the district from the standpoint of liability.
We are actually protecting the district from liability. Joe's question is actually going down a path that, in an exercise of judgment and discretion before, I opted to not pursue. But Joe is not far from where we need to be. So perhaps the questions might be coming, you know, and they're not being received as being protective of the district. But in my estimation, the line of questions and some of the comments that Joe has made reflect an interest in making sure that the district gets this right so that we are protected from liability. To me, the best course of action is look, I'm ready to vote, and I can tell you how to vote. The best way to do this is to give Ms. Attorney Nelson the opportunity, give her 3 days to talk to her client. Her client either decides to leave in an amicable fashion, or we vote, and I'm prepared to vote. So that would be what I recommend here.
Yeah, can I just remind?
Attorney Dugas, what's the timeline we're dealing with now?
We have to issue a written decision by the 8th.
5 days.
Yeah.
We've got 5 days.
Okay, so give her 2 days, bring us back on the 7th, I'll vote. I'm ready to vote. Attorney Nelson has 2 days to talk to her client. If that is not productive, I am prepared to vote on the 6th or the 7th, whenever you bring us back.
Would everybody be, what day is the, okay, 2 days from now is the 5th. Would everybody be available on Wednesday, the 5th?
I am not if you need me, no.
Oh, yeah, you're
I'm
kind of important to this. When are you available this week, Attorney Dugas?
I have negotiations until about 6:30, 7 o'clock on Thursday. I could do it after that. 6:30.
6:30, or would 7 be better?
I can get out of it by 6:30.
Okay, is that
And
amicable for now? We can reconvene on the set.
I just
Yeah.
have a question. What are we looking for in the next?
That's the next question. I just want to make sure that first, everybody can do this. Yes or no? We
No.
Good?
No, that's okay. I don't need to be there.
Okay. And the next question is what are we asking here?
She chooses to voluntarily pursue and agree to leave and get her disability pension, or we vote. Those are the only two options that there are here. Either she decides, listen, procedurally, everything has been exhausted. I've done the best I can, and I am going to go ahead and accept my disability pension or pursue it and part ways with the district, or the district will make a decision for me and vote.
Okay.
That's what I'm proposing.
So she either resigns or we terminate.
Correct.
Can we vote? Can you vote on that motion tonight rather than have to reconvene the meeting that if we do not receive by end of day on Wednesday, a letter of resignation?
I like that idea.
Attorney Dugas, is that kosher?
Sure.
Sure.
I'm a little uncomfortable with the ultimatum of resign, or because that's still putting her in a position of no longer having
Well, but
employment.
in terms of, for example, her resume or other future job applications that she may pursue, she's able to say, I resigned my position. And she can say that with a straight face. It's true. She doesn't have the stigma of a termination over her head. I think is what Dr. Fabian is saying.
Right, I'm just wondering if we could propose an alternative, because like I said, her mental capacity is not in question, so she could still perform administrative functions. Would it be possible to have a motion to offer her a position that does not require an
We don't have
administrative?
Mr. Sokolovic, can I say?
Can I finish, please? After I make.
Yeah, let him finish.
That we offer Ms. Jones a administrative position that has accommodations, not in the current school she's in, because that's definitely untenable. I agree with that. That she can be a principal on special assignment with some accommodations made. And if she does remain capable of coming to a compromise, then we could offer termination procedures. Can we construct a legal motion to that effect and have it work?
What I wanted to say, if I may, without saying anything, is your assumption about mentally and cognitively there being no issues. Don't assume that's the case.
Well, I just assume it's the case because it was not provided. I didn't see anywhere in the documentation. If you could put directly to the page in the documentation where that's stated.
I will say I do not feel comfortable bringing the individual back under any circumstances currently as an admin.
But it also sets a bad precedent, Joe. We don't want to go down that path. Neither the law nor common sense requires us to have to create a position. There are certain requirements that the law puts upon us, but that's not, this person has to be able to perform the essential functions of the job. And I think we've seen enough here that this person seems to have a real challenge performing the essential functions of the job. What you're proposing, Joe, A, sets a bad precedent. B, goes beyond what the duties of the districts are. And I think that a nice, neat resolution is what I have previously proposed. I don't object to if we don't get a letter within 2 days accepting, resigning, that we vote, or that it deems that the board has voted. I just wanted to give you a heads up, Joe, that I would not at all endorse the approach you're taking.
Yeah, but we also are not. We would not be acting without our scopes, because the process is for it to come to us, for us either to affirm or deny this. And if the state laws and the statutes wanted anything different, they can rewrite them and take it out of our hands. But for now, that this is within our realm, because if it wasn't, we wouldn't be sitting here right now.
Okay. Mr. Taylor, you're the last one with your hand up.
Yes, sir.
I'm still having hands up too, Mr. Chair.
Oh, you too. Okay.
Mr. Chair, at this point in time, I'd like to make a motion.
I have very specific motions. So
It's a very specific motion. I'm going to get on. I think Dr. Fabian has come up with a brilliant solution to this quagmire.
Taylor,
Yes.
I've been provided with very specific motions that are required. If
Okay.
you give me the substance of what you're trying to accomplish, I can incorporate it into the motion.
Well, if you'd give me a minute, I'd spit it out. So what I was saying was, I would like to support a motion that, quote, what Dr. Fabian has suggested, the resignation, disability, or we vote on termination in 3 days.
Okay. Alternately, it was suggested that we could vote to.
Yes, correct. Go, let's do what the superintendent recommended. Vote now on that, so we don't have to reconvene.
Right. Okay.
So you worded how it needs to be worded. Now,
Yeah, like I said, it's already kind of put together structurally, and it can be modified to give a window of opportunity to Ms. Walker.
That's my motion.
Mr. Benahan?
Thank you, Mr. Chair. I have questions, and I just want Ms. Dixon or can be Mr. Ford can ask me the questions that I have and I'm still waiting. Did they offer the ADA, American Disability Act to the lady? That's what first question. And
Yes.
yeah, okay, thank you. How long should an employee be out of work and cut?
I'm sorry, how long should be out of work for what?
Her or any employee should be a working cut. I don't know, Mr.
He said workman's comp.
Oh,
Yeah.
I guess 10 years. I mean, this is probably the longest case I've ever heard in 35 years of practicing law in this area.
Okay, and my other thing is, if she go out with this, well, for me, did she they can go out with disability, not termination. So she have the situation, I just go with disability and not termination. And another thing is that have been for 10 years. Why is coming up now? Because I know we give 10 years for this person, and sometimes we have 1 year out for working cup for another staff, and they remove and they have termination. Why we had to wait so many years for 10 years, for the situation? And like I said, she then go out with disability, not termination. That's my opinion. No more question, no more comment, Mr. Chair.
Yeah, let me just clarify one thing to make sure everybody's on the same page. If you were to terminate her tonight, nothing would stop her from being able to apply for a disability pension tomorrow. I just want to make sure everybody understands that. And why it took so long? I guess Mr. Testani, wearing his union hat, strung this thing out and was her advocate for a long time. And I'm being a little facetious there, Mr. Testani, but this isn't a district that, the minute somebody has an absentee problem, throws them out on the street. The district worked with her. It was a very complicated case, frankly, on a lot of levels. And I don't know how to answer it better than that. I can't answer for Dr. Johnson why she didn't move quicker, before.
And my last question for Ms. Dixon, you be the director of human resource, Ms. Dixon. Did she did break the protocol, the policy, something that you think as you are professional be human resource. Did she break the policy, any protocol, something, as you experience as human resource director?
I don't,
Dixon is not here.
I am here.
You are here.
Yeah, she's there.
You stayed silent
I'm here.
all this time?
Yes, I have.
Yeah,
Okay.
she was here. Yeah, she was here all this time.
Chairman recognizes Zaltro Dixon. Go ahead.
Thank you. Mr. Benahan, when you're dealing with workers' comp and injuries, it takes it out of the regular work rules and policies and procedures. The issue, though, you can then say, well, the lack of her attendance, her inability to perform the basic functions of her job duties. So those things tie in with regular work rules and policies, but what workers' comp is a very unique situation. It's run by an entirely separate entity, and then we get involved here and there when we need to. We have PMA who handles the workers' comp, but at the end of the day, right, it's her inability due to the injuries to work for an extended period of time. And then that, I think, adds to the conclusion that the hearing officer, Mr. Weiner, concluded that she's unable to do her job. I don't know. I hope that answers your question.
Yes, you answered my question. Thank you. Mr. Chair, and I agree with Mr. Stoney said we cannot be spending no more money. We need to get a solution, and she will be much better if she go disability. That's my opinion. Thank you. No
And I just want to add contractually to everyone's, we only had an obligation to pay the difference in workman's comp or the time off for 6 months after the injury, not 10 years. We paid and paid and paid. The district has done more than enough. And in terms of disability, she will do very well applying to the state teacher retirement disability. It will pay her a significant portion of her salary until she's eligible to retire. So we're not doing anything harmful and
She's not going to be destitute.
No, she will do extremely well. She will probably make a lot more than most people disabled through the pension, disability pension, until she's eligible for full retirement. And the years on disability will be counted as credit years as well. So it's a pretty good deal that she would be taking advantage of.
So what I'm going to do, there are two motions, and they address the two components of this. The first motion is related to the requirement that we accept the hearing officer's finding. So we'll do that first, and we'll move on to the next one, which will deal with the matter concerning the status of her employment with the district. So the first motion is that the findings, conclusions, recommendation, and reasoning of the hearing officer, Gerald T. Weiner, be and hereby are adopted in toto by the Board of Education of the City of Bridgeport, and that the employment of Gladys Walker Jones be and is hereby terminated effective immediately. So that is the hearing officer's recommendation. So we're accepting his findings of facts, but we're not terminating her by that motion. Is that understood?
John, why are we doing this? Shouldn't we should proceed with the second component of the motion? This becomes moot if she agrees to resign.
I'm just saying that we have to accept the hearing officer's findings of fact. We don't get to not do that.
So why, if we don't get to not do that,
Why are we voting on it?
Hang on.
Yeah.
So we have to accept the findings of fact, and then following that is a motion relating to termination, but we can insert something in there effective May 5th, unless the employee submits a recommendation prior.
You're locking the board into a finding that may not be necessary for us to be locked into if she resigns. So all this becomes moot is if in 2 days we get the
Okay.
resignation letter.
Okay, so
Dr.
would you like
Finley,
that
vote no like
modified then
Monday.
to be reflective of that?
Pardon me?
Would you like that to be modified to be reflective of that?
What I would like to do is vote on the motion, giving this lady 2 days to resign, or we will terminate. If we need to come back to adopt the findings, if she doesn't choose to resign, then we
Well,
come back to
all right,
adopt.
so then in that scenario, we'd be coming back anyway.
All right.
So what I had thought we were trying to do was to avoid coming back if we don't have to. But if what you're suggesting is that we may wind up doing that anyway, then I would suggest that we table this, or we postpone this matter to a point specific, which would be May 7th, Thursday at 7 p.m. And we'll either come back or we won't.
I'm fine with that.
And if a resignation is submitted, then a meeting will not be called,
Correct.
and all of this goes away.
Right. And by the way, in putting this proposal together, I'm taking Attorney Nelson at her word that she will be recommending a similar path to the one that's being put forth here. That's of course up to her client to accept. If she doesn't accept, then we come back and vote.
What do you
Yes.
think of that, Attorney Nelson?
Yes, no, that's fair. I appreciate the opportunity for her to make the choice.
So, all right, well, I mean, we've done this all in public, so, everything is on the record, it's been recorded. Is it your recommendation, Attorney Dugas, that we provide notification that we're going to potentially reconvene on Thursday?
Yes. Yes.
Okay. Do we take a vote for that? Or will the superintendent just handle that?
Yeah, I think you would just repost it for Thursday night as a special meeting.
All right, well, here's what I'll do. I will, at this point, seek a motion to postpone this meeting to continue on Thursday, May 7th at 7 p.m.
And I'm sure Mr. Testani knows this better than me, but Bridgeport has, I believe, a 48-hour notice for a special meeting by charter.
24.
Is it 24 or 48?
24.
Okay.
John, I'll
So-
second your motion.
And that is pending, pending Attorney Nelson communicating these matters with her client. Okay? Mr. Taylor, you made the motion?
I second it. Yeah.
Okay. So I made it, Taylor seconded it. All in favor?
Aye.
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 Opposed?
Aye.
Okay.
Mr. Sokolovic abstains. Okay, Attorney Nelson, you're clear on where this is going.
Yes.
If we hear back from you with a resignation by the close of business on May 6th, we will not proceed any further with this.
Fair enough.
But if we do not hear from you, the meeting will be posted.
Okay, I will communicate with Attorney Dugas, and I very much appreciate your attention tonight. Thank you.
Okay. Thank you. All right, we have the other item on our agenda. You don't need to be here for that, so thank you. Next item on the agenda is discussion and possible action regarding a new employment agreement with Michael J. Testani. This item also qualifies for executive session. Mr. Testani, you're familiar with the statute. Are you going to require that we hold this discussion in public?
No.
Someone want to make a motion to go into executive session to discuss this?
Mr. Chair, if I may, real quick.
Sure.
It says, new employment agreement. Does that mean we're vacating the old employment agreement and signing a new one?
You want me to answer that?
Go ahead. Attorney.
You cannot have an employment agreement under the statute for more than a 3-year period of time. So typically what's done is you would create a new contract for 3 years and the other one becomes null and void once you've done that.
Did we get the new contract yet?
I don't think there isn't one.
We haven't, we're going to talk about that.
Okay, so we're going to just, so I understand,
Uh-huh.
before we go into executive session, we're going to have a discussion about a new employment agreement. And so we're not taking action on it tonight.
We may or may not.
Well, how do we take an action on a new employment agreement we haven't seen yet?
This is what I'm saying. We need to talk about that. We may not, but I think we're going to start with what we have existing, and then it's going to go from there. And we can do one or two things. We can agree to that, or hang on, let me finish. Or we can instruct someone to draw up this new agreement, send it back to us, and then we vote on that.
Just my personal opinion, and this agenda seems a little misleading to the general public. It doesn't prevail for any public comment. And a new employment agreement, just so I'm clear why everybody we're still in public hearing right now, is there going to be a new, so there's not going to be a new agreement introduced tonight that has to be voted on, because I haven't seen it yet.
Well, we'll decide that when we come out, if we want to make any kind of vote or we want to postpone it further. So if you want to see, here's the way I'm seeing this. We have an existing agreement that has existing terms and conditions.
Correct.
That would be, I think, our basis. And if there were to be any changes to it, after those changes were discussed and agreed to, if they were really minor, we might just proceed. If they were really involved, we might ask Attorney Dugas to type up a whole new one and present it back to us.
Were we provided the old employment agreement for this meeting? We were. Okay.
Okay.
Yeah, I'll just say publicly, and this isn't, I hope I don't offend anyone. I don't think it reads well to the general public. So that's just my 2 cents.
Okay. Is there, Mrs. Kolovich, you got your hand up?
Yeah, I would like to just refresh our memories and state why I don't think it would be a good look, as Mr. Taylor says. It's not definitely a good look. I got a little brief, it took a minute or so please bear with me. We started off this process in 2019 with the forum when Mr. Testani, when Mr. Testani was selected for the interim contract, 6-3 vote, and there was a cannot apply clause. I was one of the 3 no votes. It also calls for an interim evaluation in January 2020, and also at the end of the 1920 school year. Neither really happened. On January 6, 2020, at a special board meeting purportedly to evaluate the superintendent, the board was given a sheet of paper with 5 evaluation questions, 3 each for comments, and a rating system from 1 to 5. I get longer surveys from Uber Eats when I rate a restaurant. But this was enough to offer the superintendent a 3-year contract in opposition to the stipulation in his interim contract that he need not apply. 6 months into his acting contract, Mr. Testani was awarded a new 3-year deal without negotiation, and more unbelievably, having a single board member reading the contract they approved. This contract was approved by 7-2 votes. Once again, I was one of the no votes. Important to note that there was never a year-end evaluation as the contract called for. The board had voted to give Mr. Testani the same contract Dr. Johnson had, and there was debate on a residency clause in the contract, which was ultimately included. That brings us to today, Monday, May 3rd. Almost 2 years since the superintendent was hired as acting superintendent, still no evaluation to date on which to base a rationale of a contract extension, yet here we sit in the comfort of our own homes, hiding behind our computers, once again in a special meeting prohibiting public input on the most important function we were elected to carry out as board members. Once again, we are about to vote on extending a contract and the public has not even seen, because the contract of one of the city's most highest paid employees is not even included in the public package. No idea of what we're even amending. This contract does not expire until 2023, 2 years from now. What is our rush? Why not wait until the following parameters are met? Superintendent Testani has an evaluation that is contractually scheduled to take place no later than August. This will give Mr. Testani a chance to give dispassionate, objective data to allow the board to make an informed decision based on facts. Superintendent Testani, second one, Superintendent Testani establishes residency in the city of Bridgeport as required in Section 2 of this 3-year agreement. I asked this board to postpone action on extending the superintendent's contract. Doing things by shutting out the public without a single evaluation makes the public suspicious of the board and the superintendent. I can't say I blame them, because I myself find this process suspect and will be voting no for the third time due to a lack of data to make an informed decision and also a lack of transparency. The board does itself, Superintendent Testani, and the public a disservice by doing things in this manner. I'm probably wasting my breath, and this extension will be granted. With me voting no for the third time, maybe by myself, maybe with one or two others. I ask you, Mr. Testani, not to put me in that position and withdraw your request for a contract extension at this time. Barring that, I move that we postpone this meeting until after Mr. Testani establishes residency and received his very first evaluation in 2 years.
Mr. Chair, may I just say one thing? Can we move to the executive session now? So then I can respond?
Yeah, let's.
We're still
Mr.
discussing if executive
Hey,
session
stop,
takes place.
hang. Dr. Fabian has his hand up.
I was just going to suggest that we move to executive session so that we can have a full discourse as to why I am strongly in support of granting Mr. Testani an extension of this year, both for his remarkable service during one of the most difficult years that we've experienced in history, but also I have to commend him for his ability to both work with our parents and work with this board. I just heard Joe Sokolovic's what appeared to be, quite frank, some type of election speech. I want to make it clear that what Mr. Testani is asking for us here is not a favor, but something that through hard work, dedication, commitment to his community, he has earned. And I am here today to reward him for what he has done for our student. So I want to go to executive session and I want to put the political speeches out of the way.
Point of privilege, Mr. Chair.
Is there a second? Hang on. Is there a second?
I second that. I second.
Personal attack by Dr. Fabian, who shows up every once in a while, just got.
And you're engaging in your own personal attack. All in favor of executive
No,
session?
we're still discussing.
We're
still
not.
discussing.
All in favor?
What is the motion? What are we going into executive session for?
We are voting to go into executive session
We were supposed
to
just-
discuss a new contract with Superintendent
We were
Testani.
all
in favor?
Wait, what are we talking about the whole contract? Because the email we got, we were supposed
We're
to only
gonna
be going into an
Yeah, the whole
extension.
contract, Joe.
So we're gonna go in there and maybe give them a $40,000 raise with no public input, without no evaluation.
Yeah,
Or we're
this
maybe
is
gonna
the-
give them extra vacation time,
Yeah.
or we're maybe gonna remove the residency clause without any public knowledge. We just had a public session on the last agenda item. Why can't we discuss in public now? That's not a political speech. Political is going to executive session and saying all the things I'm saying out loud, like a person with morals and convictions, going behind closed doors and hiding what we say and not being able to disclose what anybody said. I'm always open to say what I have to say in public.
Okay, there's a motion that's been made and seconded. All in favor of going
Motion
into
to
executive
amend.
session?
Motion to amend. I would like
What's
to-
your amendment?
I would like to, my amendment is that we go into executive session to discuss only the extension of Ms. Superintendent Testani's contract. And limit ourselves to discussion on the extension of the
That's
contract.
not what the agenda item is. That would be fundamentally changing the agenda item. This is a new agreement. And all things are on the table.
Well, let me say this.
And that's the way the agenda item reads. It's a special meeting. We can't change it.
What is our rush? What is our rush? This contract does not expire until 2023. No harm will come to Mr. Testani. No harm will come to the board in waiting 3 simple months to establish.
May I say something?
At this point, you're kind of dominating this, and a motion is on the floor to go into executive session, and I'd like us to just vote on it so we can continue the discussion. So all in favor of going into executive
Do
session,
we have a roll call vote, John?
signify by saying aye.
Do we have a roll call vote? Please.
Chris Taylor.
No.
I'm sorry, you know what? This is Mr. Lombard's role. Mr. Lombard, would you conduct a roll call vote?
Chris Taylor,
No.
Albert Benahan,
No.
Joseph Olivic,
Oh, we're voting on my amendment.
Not to go into
No, we're going
executive
into
session.
executive session, yes or no?
Well, oh, yeah, I was the second. No.
Sybil Allen,
No.
John Weldon,
Yes.
Cosmo Fabian,
You're muted, so Sima.
Yes.
Bobby Brown,
No.
and Joseph Lombard, yes.
Okay,
Motion fails.
5-3. Okay, so we're gonna have this discussion publicly. I'd like this, I've observed some combative dialogue in this. I'd like us all to just kind of take a step back and try to be professional. So, Mr. Testani, per his contract, is permitted to, within a very specific time frame, make this request that we consider a new agreement. Now, since he's the one who initiated this, I'm going to ask him what he would like to see out of this. Mr. Testani,
Mr. Chair?
what is your point here?
Mr. Chair, I apologize for interrupting, but can we bring the contract up on the screen so everybody can see what we're talking about? Because the public has not been provided in the packet this contract at all. And I believe this
Are
is
you
a
able to bring up the
document.
contract, Mr. Testani?
Hold on a second. I will do my best to get the contract up for everyone to see. Okay, give me a second. I'm pulling it up. Here we go.
Okay.
Everyone available? Can I say something since this was the
I'm
request?
turning this over to you.
Thank you. I appreciate it. So in Article 4, Section A of the contract that was afforded to my predecessor and also provided to me. Prior to the end of the first year of a 3-year agreement, the Board of Education, at the request of the superintendent, may vote for a new agreement prior to the end of the first year. The rationale behind this is you cannot go into the second year of a contract without sending a message to the district that there's a commitment level toward the leadership in that district. The Bridgeport Public Schools has had 5 superintendents over the last 10 years. Inconsistent leadership has made recruitment and retention of high-quality staff extremely challenging. Instability has deteriorated the climate and culture of the school district as a whole. This impacts the level of teaching and learning of our children. Consistent leadership and longevity will allow me and the Board of Education to implement positive and meaningful changes to move our district forward. If my contract is not extended, it will send a clear message to the entire staff that what I am asking for them to do for our students may not last. They will once again brace themselves for another superintendent with new ideas and new expectations. We cannot continue on this revolving door of leadership. We need to show our commitment to leadership and to our school community. Longevity will allow for positive change and positive outcomes for our kids. It will attract strong
Mr. Destani, sorry. I'm sorry, Mr. Chair. You read something that I cannot read it. At what page? Because whatever you put there, I cannot see what you're reading.
He's talking, he's not
I'm
reading.
talking what's.
Oh, my apologize. Sorry, my apologize.
Excuse me, gentlemen, could you have Rita Valier send me the contract? I can't find it. I didn't get a board packet, or maybe I did and lost it.
Ms. Valier, are you able to send him that?
Mr. Grassi will assist in the matter, sir.
Okay.
Thank you.
I needed to because
Continue,
we
Mike.
didn't receive it either.
Should I continue or should we just reconvene again for another meeting? Because I'm trying to provide the rationale behind what we're trying to do here in the district, and it just doesn't seem to be acceptable, I guess.
Motion to postpone?
No, well,
No,
I want to say,
no,
we
no,
took the time
no.
to be here.
This, you know something? At this
No
point,
Go ahead.
The contract doesn't expire for 3 years.
Hang on, Joe. The superintendent is trying to say something.
again, without consistent leadership and commitment to our school community, we cannot move forward with positive change and outcomes for our kids. The evaluation done separately will allow the board to give me targeted areas to focus on while improving my path to continuous growth and improvement, while it gives a clear and positive message to staff that we are committed to the leadership team. We must work collaboratively to establish goals and achieve success for our students of the Bridgeport Public Schools. That all aside, I'm going to have to mention, we have gone through 14 months of a worldwide pandemic. The Bridgeport Public Schools has provided more in-person learning and support to students outside of any other district in this state. New Haven and Hartford have not come close because we're always comparing ourselves to the level of funding. We're the most underfunded district in the state, yet we've been able to achieve accolades from the state and from the Secretary of Education of the United States of America for what we've been able to accomplish. I'd like to think because of my leadership, we've been able to accomplish so much for our kids. And yet we sit here today and try to rehash things that happened in the past. That is not abnormal to other districts across this state. Other districts hire interim superintendents, and within a couple of months, if they are satisfied and happy with the progress of that district, they offer them a contract. Why? Because it is hard to find high quality leaders in this area. It is hard to find. I'm not going to continue to make apologies for what has happened well over a year ago. I am going to sit here today and say I am confident in the work that we're doing as a district. I am confident as the team here, the Board of Education, the 8 members that are here tonight, working alongside and behind and supporting me, what we've been able to do. So if we want to continue to rehash what certain members of the public feel, and that is what we're basing it on, I am basing it on 20,000 school children, 3,000 staff members, and the rest of the Bridgeport community who has recognized what we've been able to accomplish is monumental. And I'm going to leave it at that. If that is not enough, I don't know what else I can do. I really don't know what else I can do to say, hey, great job. You've earned this.
Dr. Fabian, you had your hand up?
Yes, I just want to follow that. I think Mr. Testani in his presentation highlighted why we should go ahead and give him, and the sole issue here, just so that those who have brought in the public, so that the public understands, the sole issue that is before us at this time is whether there will be a 1-year extension of the contract. Excuse you, I am speaking. I am stating that it is my
Point of
understanding.
information.
Hey, no, let him
The
finish.
point of information is valid when erroneous information was given. We've said before we go into an executive session that the whole contract was up for.
It is up.
The
Well,
whole
here's the thing,
contract,
Joe.
not just
Hang
the
on,
1-year
hang on.
contract.
Here's the thing. I need you to stop for a
I just
minute,
wanted to clarify that.
or I'm going to ask that you be muted for a minute, because this is an issue. We started going down this path, and we said we were going to talk about this contract. I didn't even get to the point where I asked him, is there anything else in this agreement that you want to discuss? Instead, this meeting went sideways, and it, quite frankly, I think it offended the superintendent, and he responded accordingly. And now this has spiraled out of control. So if we take the time to just ask him, is there anything else in this agreement other than the start and end date that you want to put on the table for discussion? And then we make a list, and then let's talk about it like adults, instead of talking about what happened in the past and who got who angry and what you think should or should not have happened. Can we get to that point where we just have a discussion on what's on this side of the ledger, what's on this side of the ledger?
See, well, my point was, the only reason I wanted to go into executive session was not because I can't have the conversation in public. It's because we need to have
this.
We need to have a professional conversation, and it doesn't become a professional conversation. And then I have to read in the newspaper tomorrow what the comments were and the social media and everything else. And that hurts my reputation, because I am not an elected official. I'm an employee of the Bridgeport Board of Education who has done a damn good job for the community that I serve, that I was born and raised. I've been here for almost 50 years of my life. So when it comes down to it, am I offended right now? You're darn right I'm offended, because I don't know what else I can do. I don't know what else anyone else would have done any better. And if we want to continue to go on public trust, if no one trusts the process after what has just happened for their children, their nieces, their nephews, their cousins, I don't know what else to say to them. I really don't. Because now I feel like I've been disrespected.
Absolutely.
Because I've shown respect to every member of this board at all times. I have given you 110%. I didn't miss one day in the office since day one when we closed on March 12th. I didn't hide at home. I didn't work in my living room or in my basement or on the couch. I was here because this is where I needed to be, to set the example of what I expected from my staff and what the community expected from me. When this building was closed, I snuck in here every day. So today, yes, it's on the record now. I hope people are watching. I hope people are tweeting. They're making their comments on Facebook, because enough is enough. This district needs consistent leadership in order to grow. It needs somebody who's going to be a leader, not run away with years left on their contract. I want to stay here. I want to be here. Not many people say that. I am saying it today. This is where I want to be. These are the kids and the families that I'm committed to, and the staff that I believe in can get the job done. And I will end it there.
Dr. Fabian, you were cut off.
John, I think we should go ahead and narrow the issue as you propose and ask the superintendent what's on the table.
It's not that hard. So, as I started at the beginning of this whole thing, Mr. Testani, I'd like you to provide a list of any and all items in this agreement that you want us to talk about. We already know that the issue of the start and end date, that's item 1. So term is item 1. Is there any other element that you want to talk about tonight?
Tonight,
As
there's
part,
no,
well, no, let me, because we may not finish tonight, it's getting late. As part of this discussion, is there any other element that you want to talk about?
yes, tonight I would like to talk about a couple of other items. I'd like to have something included in the contract that upon favorable evaluation, that there's a percentage increase to my annuity contribution each
Okay.
year. That can be discussed at a later time.
Okay. Anything else?
Yes, I'm gonna need a little bit more time to establish any residency. And I don't see the harm in giving me more time, given the circumstances and given that there's no real rationale as to why someone who lives 5 minutes away from the office wouldn't be afforded more time.
Question why we even have this to begin with. Is there anything else?
Nope, that's it.
Can I get clarification,
Who's this?
Mr. Chair? Mr. Joe Lombard?
Lombard?
So clarification is simply to establish consideration to establish more time to establish residency, or the issue of establishing residency altogether? Is it just to have more time?
I personally think he lives.
No,
in-
Mr. Chair. I'm
Let me
asking
finish.
Mr. Testani. Well, I want to know what he thinks. It's up
Okay,
to
what do
him.
you,
If you'd like to know what I think, I don't see why it would be required to do my job. I do not. Well, and I don't like I could see the body language of folks, and I think it's disrespectful because, again, there seems to be some correlation with effectiveness of the job and residency. If there is going to be a residency change, then yes, more time and some sort of accommodation for that. Because
by accommodation, do you mean financial accommodation?
there's going to be a cost associated with it.
What the fuck?
But that's just my,
I
You know,
just wanted to ask, because if we're going to consider it, we should know exactly what we're considering.
and
Yeah,
that,
So it doesn't-
absolutely. I've seen people come into employment agreements like this. They come from out of state. So clearly you're going to require them to move into the area. I've never seen a requirement where it gets so specific as to where you live. And if there is a relocation involved, there's a stipend to cover real estate closing costs, real estate commissions, mortgage closing costs, the physical cost of moving. And I don't see a business value to that. I don't see where his moving to within the city limit makes him a better operating superintendent.
Then why did you make Dr. Johnson move to Bridgeport?
I did not make her move.
Yeah,
to
yes, you
Bridgeport.
did. I was there when you did it.
Dennis Bradley
I've
did
had my
that.
hand up. I've had my hand up, and I've listened to this. I'd like an opportunity to address the board, sir.
Okay, go ahead.
I voted for Superintendent Testani. The sole reason I was a deciding vote for him to enter this contract.
Well, you weren't deciding.
What's that? Well, okay,
I don't
but,
think-
well, all right,
Go
fine.
ahead.
But nevertheless, there's a residency. Dr. Aresta Johnson was forced by members of this board to move from Waterbury to disrupt your home to move to Bridgeport. Superintendent Testani, who I think does a fabulous job, I would gladly honor an extension. I would go to a 5-year contract and give him an extra $35,000 a year in a minute. I love Mike Testani. He's a great superintendent. He cares about the kids. He cares about the staff. He's gotten federal recognition of Bridgeport. He is a shining star of Bridgeport. But how do I negotiate with a man that has not honored the contract he has signed? The contract required residency within 1 year. We extended it till July 21st, till after his stepdaughter graduated high school, and he agreed in a public forum that he would move to Bridgeport. I don't negotiate after a contract is signed. He signed the contract, honor it, and I will support him 100% in whatever he wants to do moving forward. But for this board to make a recommendation to give him money to cover closing costs or a stipend when they did no such thing for Dr. Aresta Johnson leaves me to believe this board is favoring a white male over a black female, is the only indication that this is. And I apologize for being so upset about it, but nobody on this board at the time Dr. Johnson was here did this for that young lady. No one. Mr. Chair, you were present. I don't remember the rest of the board members at the time, but Dr. Johnson was held to this criteria, and they checked, and they made sure that woman moved here. And now we're going to have a guy that's got the job that people say wasn't qualified, that I said he was qualified for, won't move to Bridgeport, and the chair wants to give him more money. You're off your rocker. That is, I will support Testani. You want to give him a pay raise? You want to give him 5? I'm good. I'm in. He's done a great job. He's navigated the pandemic like no other superintendent. The guy is phenomenal. Absolutely phenomenal. I wish you would improve relations with the 1522. I wish you'd get along with labor a little better. If I had my magic wand, that's what I'd wish for. But the residency with me says it all. Tell him to move into Bridgeport. He's got 100% of Chris Taylor's support. I don't know what the rest of the board thinks, but just remember, you guys made Dr. Johnson move from Waterbury to Bridgeport. And you didn't
sure did. You sure did. You sure did.
Yes. So that's my only gripe. I've made it very clear. Superintendent Testani agreed to it in the meeting. It's on video. It's on the record. Honor his agreement. Do not negotiate after a contract is signed. And I will extend his contract with, I think he's worth another $35,000 a year. That's my opinion. That's all I have to say on that matter. Thank you, Mr. Chair.
Okay. Dr. Johnson negotiated her contract with her attorney. She made the choices she made.
Yeah. Well, nobody on the board wants to give her a slice, John. John, you're out of order. You're out of order.
I'm answering what you said. She negotiated with her attorney.
Mike Testani.
And she made the choice to enter into the agreement she did.
So did Mike Testani.
What?
Mike Testani entered into this agreement fully knowing what the agreement was.
Okay, can I just interject, Mr. Chair? I'm not going to make this a male, female, a black, white thing, because I don't think this is what it's about. And I'd hate for it to go down a road that it shouldn't go down. So in Mr. Taylor's defense, yes, I did agree with Mr. Taylor. I'm not going to deny that.
Thank you.
I am not here to do any of that. So if that is the case, and you are willing to then provide me with a new 3-year contract, if that provision doesn't come out, there doesn't need to be a stipend. If you're suggesting that, then I will request a percentage increase of my salary, since it has been the salary for 4 years now in Bridgeport, and it is not very competitive with surrounding districts that are comparable. Number one being Stamford, who makes a significant salary more than Bridgeport does, with less students and less schools.
So,
go ahead, Joe.
So I just want to, so what we have for the term to be extended, we have for a percentage increase to the annuity contribution, we have more time to establish residency, and we have an increase in salary.
I will withdraw the more time. I have been looking for a resident, and I've made that clear within the last month. So it's not right now the easiest time to find something very quickly. But there has been, I've been working with a real estate agent to find a location in Bridgeport.
Well, at this point, anything is more time anyway. So
well, I have July. So
To July, okay. All right, so we'll take that off. So the term, extension to term, percentage increase to annuity contribution, and now an increase in salary. So those are the things.
That'll be the end of it.
Okay, all right, thank you.
If that satisfies Mr. Taylor and anyone else who has an issue.
Listen, I'll go, like I said, I'd like to give you an extra 35,000 a year. I don't want to go for the annuity increase. I'd give you one or the two. That's just me. I'm only 1 of 9, but as long as you live in Bridgeport, you were one of the hardest working people I know. You've done a fabulous job. I support you 100%. You're all Bridgeport. Let's stick to the contract, and I have no problem supporting it. I don't know about the rest of my colleagues, but I think you're doing a great job. I don't think anybody else has navigated the pandemic as well as you have. You've been federally recognized. Yes, we get complaints, but we get compliments too. So you've done a very good job, Superintendent. If we can get better relations with the 1522, I'd be really happy, but you're doing a good job.
What are we defining as residency? Let's get that clear.
Bridgeport.
Ownership
To
or
live within the confines of what is known
Hang
as
on.
Bridgeport.
But does it have to be ownership or can it just be residence?
No, he can live. He can live in his car.
Everybody.
I don't care.
This is why we go into executive session.
John, you asked
Are
a
we
question.
saying that?
No,
he
we're on the
must
record.
live in a certain place, a certain percentage of the time? Or are we saying that we throw him a bunch of money and he rents an apartment that stays empty and it's really just a
Hey,
joke?
John, I'm not the residency police. As long as he lives in Bridgeport, if he's got a
We know
Bridgeport
that.
residency,
We
I
know
don't care
that.
if he rents or lives in a shopping cart. He's got to be in
No,
Bridgeport.
but, see, here's what I'm saying though, is that we've had embarrassing circumstances surrounding where people do or don't live.
Absolutely, I'm one of
I
them.
do
I'm
not
one of
want
them.
to set the stage where Mr. Testani feels he's got to rent a room in a rooming house that he never lives in to satisfy a fake residency. So let's define what residency.
I'm not gonna rent a room in a rooming house.
You know what, I'm being facetious.
We're going down the
Rent this
wrong path.
apartment and then never going there. I don't want to see that because that's going to come back as an embarrassing thing.
I was excited. I was excited to talk about the positivity and the positive outcome that this man has brought to the district.
Yeah.
And this is where we are. And this is where we are.
Yeah.
It's unbelievable.
Welcome to the board.
And all because one individual, maybe two, have a fixation with residency and the possibility of him, just renting an apartment, leaving it vacant and showing up with basically a fake lease. And we're going to pay him to do it. We're going to
No,
pay
you
him.
wanted to pay him to do it. It's in the contract.
So he can pay his rent for a place.
No, I'm
he
giving him a
doesn't
raise. I would give him a raise because he did a great
That's
job.
what you-
I guess we're coming from different cloth.
No, because we're supposed to give him an evaluation.
Can we stop?
That's
please,
what a raise
because-
is for.
Can we
Yeah, but you
stop?
were all for making Dr. Johnson move,
Can
weren't
we
you?
stop, please, everyone?
Mr. Johnson is
We are
3 years
public.
ago. We're not
Yeah,
talking
3
about
years ago you made a move to the Waterbury. You're okay with it then. You don't.
Mr. Chair, can I have the floor, Mr. Chair?
Mr. Chair, who muted Mr. Taylor? I believe he was still speaking.
Mr. John, you was mute. You mute again, Mr. John.
Stop it. Don't do that again.
I don't know who did it, but Mr. Chair, can I have the floor, please? I'm waiting for it.
Go ahead, Albert.
Thank you. And please, my friends, do not interrupt me because I interrupt nobody and I will listen to you and I respect all your opinions. Mr. Testani, the reason I say do not go to executive section because we are working together is nothing to hide. If you think I'm offend you, please apologize because I don't need to offend you at all. We are friends for almost 20 years, but I don't mix friendship with business. The reason I would like to get this situation be done, yeah, Mr. Testani, you're doing an amazing job, and I respect and I take out of my hat for you because I know others superintendent the school they say the name, they will be high, they will run away, and you was there for the day one, and you never give up. A special extra days off and everything, you was there. You never give up. But that you did things, and I'll be honest with you because I don't need to hide that you did things that I don't like. that employees they're not happy with you, that you do stuff and make decisions that I was not happy. And we talk about this. So nothing is perfect. And I know from the beginning you told me, and I remember former Mr. Hernan told me things going up and down and nothing is perfect. But people, they get upset with you, and I get upset with you. It's normal because we're not perfect in this situation. But if you did a good job, what you're doing, I respect that, and I would love to you stay here in the Bridgeport. But I don't, if the Miss Aresta Johnson decide to move to Bridgeport, I was not a board member. I was only a leader. That she made that decision, and who will make that decision. Now in your contract, and I believe the contract, and let's talk about the present. Let's not talk about the past. Past is past. It's done. Finito. Adios. No more. No más. So let's talk about the present, because it's a shame that we have to go through this. A lot of people from Bridgeport School in another state, they're watching us, and this is why I don't like. I don't like when people say, "Look at the Board of Education of Bridgeport School, what they're going through." And trust me, it's a shame. It's a shame for me that we have to go through this. That I don't see in your contract, Mr. Testani and Mr. Well, that you answered that question on Ms. Dixon. They say in your contract you have to move from Bridgeport. If they say it, okay, you have to move it. If they don't say it, let's keep forward, please. Let's keep forward. And then not a lot talk about the past. They'll be the present, because there's a lot of parents, students, staff, community. It's watching us. And I don't like when people say about the Board of Education, look at what they're going through. I'm a board member. I represent Bridgeport. And it's a shame that we have to go through this. No more question, no more comment, Mr. John Gordon.
Okay. We haven't heard anything from Ms. Brown, and she's raised her hand.
Good evening, everyone. I heard everything that was said. And my personal opinion is Mr. Tassani did an amazing job, and he will continue to do an amazing job. But I wasn't a part of the process, neither was Albert. And from a perspective, we weren't a part of that initial contract. But now that we know where it stands, I do want to follow what is procedure and what is set. And unless something has changed from the board perspective or the contract perspective, then fine. But I do want to honor that. And then the second thing that I would say too is, being in the public forum, we have a responsibility as board members to make sure that the public is aware of what is going on. So I would say from my side of it is, I don't want to offend Mr. Hassani in any way, but I also have people who call and they want to be a part of this process and know what is happening. So as to why we say don't put politics in the middle of it, this is not the sense of politics. This is saying making sure everyone who holds us accountable, we do our job and hold our leadership to accountable. So I just want to clear the air on that, but also to understanding too, we are in a public setting, and the behavior that we display here is also what other people view the board as. View the board overall. So, I'm looking at it that way. And, like I said, I don't know what was done in the past, but here in the present, I want to make sure if it's in the contract that we honor what is in there. And if there's a position to amend whatever, then be it so. But if not, then let's move forward.
I agree with you, Ms. Brown.
Fabian?
You mute, Mr. Fabian.
I just wanted to say that at the beginning of this process, I was actually quite excited because I have seen firsthand the impact of good leadership. I also understand the importance of stability in a leadership position. I think that the citizens of Bridgeport, both students and parents, would benefit from having someone who openly states that they want to be here, not merely because they want to be here for the job, but because they're ingrained into our community. I am excited to support Mr. Testani for this extension, not merely because of the exceptional job that he has done during this COVID period, but also because I identify it as being something that is good for the district. Stability is important. Having the ability to say that we are moving in a continuous fashion without interruption, with clear vision, is critical to the education of our children. I was not a part of this board when this last contract was entered into, nor am I a subscriber that residency requirement is essential for good leadership, for excellence, for commitment to our community. Do I understand that there was a contract that was signed and that the contract should be followed? Absolutely, absolutely. But what I don't agree with is taking this clause that has not been comported with to the full extent and using it to create, I mean, this man, Mr. Taylor did it in part. He did it in part, but we should really be, complimenting this man, encouraging him to continue to excel. This is less than inspirational, the way that we have addressed him, the way that we have treated him. It doesn't show the gratitude that, in my opinion, as a parent, this superintendent deserves for the many sacrifices that he has made. And to the people of Bridgeport who are watching, look, you have a good leader. There's a lot of talk about the past in Bridgeport. We're looking forward. We want to move forward. We want to do better. And in my opinion, both as a former educator and as someone who has lived here for a long time, we have the right person in Mike Testani. And that is why I would wholeheartedly support an extension of the year, and I am willing to engage in dialogue, constructive dialogue, as to how to go about addressing the other issues that he has put on the table. But the key word is that it has to be constructive, and we must show this superintendent, who, by the way, I think has the patience of a saint to be able to work with this board, the utmost respect for the sacrifices that he has done. So that's the way I see it.
So the way I'm reading this is everybody seems to be in agreement that they want Mr. Testani around for at least the next 3 years. Is that a fair enough statement? You're not interested in replacing him at this
Absolutely
point,
not.
correct?
No,
There are
never.
some.
He's here for so many years, Mr.
Okay.
John Weld. I'm sorry.
And,
Why are we
before
going
you
to have
move to a vote,
somebody else to replace him? No, he knows what's going on in the system. We don't want that.
Okay, so I'm just saying, if we can all just agree that we're of common mind about that. So nobody
Yes, we're
here,
not trying to replace him.
nobody here would have a heartache in creating a new agreement that started July 1st and went for the next 3 years for the sake of leadership continuity. These other elements aside, we're just talking about this one thing. Is that a fair statement?
I got my hand
Because
up.
because here's the other, we can just leave everything else in the contract alone and just say, we're going to carry this agreement in a new term. We're going to leave everything else the way it is. And we can talk about those other things another day. Maybe they are contingent on a performance evaluation, such as performance increases or increases to annuities and any of that stuff.
Mr. Chair, I had my hand up for quite a while.
Yeah, I'm actually looking at you, waiting for a response.
Oh, yeah, I can't
Thinking
see
you
that.
can see me.
Oh, no, I can't see you looking. Yes, first I'd like to basically address some of Mr. Testani's complaints. I would not like to apologize for offending him because I said nothing offensive to Mr. Testani. I did not judge his work product. I did not say whether he's doing a good job or a bad job. Mr. Testani seems very confident in the good job he's done, as does the entire board. And why doesn't this confidence translate into giving me the opportunity and the public to hear why I'm saying I think Mr. Testani is doing a good job? Because every single board member who spoke said, in my opinion, or I think, but nobody could point to data, why they think, why they form their opinion. For instance, Mr. Testani's confidence, if he could put that into evaluation, he's given some of us some data that would be essentially in an evaluation. I haven't even taken a position yes or no based on his performance. I've given a position yes or no through the process and the need to bring back to the people who voted for me why I made a certain decision. He could go through his evaluation and for the first time get 100% people voting yes on his contract with anything that could be negotiated at a later time. But at this point, to rush a contract that does not expire until 2023, where we will still have the continuity. By delaying this 4 months, we still have the continuity, and you could have possibly the support of the full board. And there's no disrespect intended. If everything bears out as he says, as I suspect it will, I would not be opposed to renewing the contract. My only concern is the process. Us, the board, we should be insulted by the way we are doing things.
Can I respond to that real quickly?
So I'm just to clarify something.
I just want to.
Contract specifically says that this kind of thing happens prior to the end of the first year. Once you cross over into July 1, that's it. That window has closed. And now you're going to go back and try to change the contract when, if you just followed it at the beginning.
Yes, the superintendent may request, not the board must.
No, the superintendent, the board may vote for a new contract prior to the end of the first year. It doesn't say prior to the end of the first year or any time thereafter.
Can I just add something, please? Again, I think what I was trying to read earlier and to say is this was after heavy consultation with current, former, retired superintendents from all over the state of Connecticut. The two are separate decisions. The extension and the evaluation do not go hand in hand. Unless you feel there is something egregious that is happening. Evaluation is for professional growth and development, not to hold on to your job or not. The extension is a statement. It's a strong statement. It is a vote of confidence for leadership. That's why they are separate. This is how it's done all over. I don't understand why Bridgeport seems to always have this feeling that we have to do things in order to show someone, if there's nothing to hide, and if you believe strongly in what we're doing as a district, then what is the problem with saying it and being proud to say it? I am proud to sit here on this team's meeting about everything we've accomplished. I am proud of what our staff has done. I don't need anybody's approval to say, hey, this is what I believe in. I believe in this principal. I believe in this teacher. I don't need the evaluation to show me that. The evaluation is for professional growth. So when I sit down with that principal or that executive director, hey, here's where you're doing great. Here's where we want to get to. That is what evaluation is. This is not a checkoff. This is about providing feedback. And you need to provide me with feedback. If you think I'm going to give you a binder this thick to tell you everything I've done so that you can say, hey, good job, that's not how it works. That's not how, maybe there's this illusion here, but that's not how it works in New Canaan. That's not how it works in Westport. That's not how it works in Farmington. I will provide you with information. I will provide you with self-reflection. This is about growth. You need to provide me with feedback. That's evaluation. That's the responsibility. So I don't know what else to say. I've said enough. I think you have all said your piece. To say that how things are meant or not, I get it. I have thick skin, believe me. But this meeting, again, was not, it could be held public every time. I have no problem holding a public meeting because I have nothing to hide. What I expected was exactly what happened. That's why I wanted to go in executive session, because we don't come out, none of us looking good. And unfortunately, the one who's going to get all the comments tomorrow and all the is me. Because people are tired of seeing the person, the face of the district, treated in an inappropriate, disrespectful manner for the sake of constituents. Because the constituents here are children. Are children. That's who the constituent base is. Unfortunately, they can't go to the polls and vote, but those are the people that I look out for, the children of this district. Whoever doesn't like the decisions made on behalf of the children, I'm sorry, but I have to live with myself, and I live with doing right by kids. That's been my career from the time I started until the day I walk away. And Joe, you know that just as much as anyone. The well-being of children comes first, and that's what we all need to understand. However this shakes out tonight or next week or next month, this is it. And unfortunately, you know, maybe I wear my heart on my sleeve a little bit too much, but not to be supported after all of this 100% is a smack in the face. It really is.
Mr. Testani, I don't know who doesn't support you. I think every member here supported you. I don't think that's an accurate depiction at all. I support you 100%, and I'm your biggest cheerleader. My only objection was the residency requirement that was in the contract. You've done a fabulous job. I don't think a board member here said a negative thing about you. Honestly, I think somewhere along the line of translation, it got confused. Nobody's got a problem with your performance. Nobody's got a problem with anything you've done. Not everybody's going to be happy, but on a whole, you have done an absolutely fabulous job.
So let's vote on the 1-year extension then. If that's the case, we can get that out of the way.
That's my initial suggestion. We can just carry the whole agreement forward.
Why am I going to extend a contract that hasn't been honored yet? I mean, get into Bridgeport and you have
this is where I think Mr. Testani gets offended, because when we say things like that, when we're saying that we're only going to give him an extension if he does something.
No,
it's almost extortionist in nature, and that's what makes him feel like it isn't about whether or not he's doing a good job. It's whether or not he's living up to
then let's rip up
something more political in nature.
Yeah, it's not political in nature. It's a contractual obligation, John. It's not a big deal. This board made arrests to do it, which Dr. Fabian wasn't part of. Bobby Brown, I don't think Joe Sokoloff was on. I mean, at the end of the day, this board made a woman uproot from Waterbury and come to Bridgeport. It's in his contract. Just do it, and I shut up. The guy's great.
Okay,
but
well, he's not.
You got to honor the contract.
We're going to
How do you negotiate with somebody that's not in compliance with the contract?
We're not negotiate. See, this is what I'm saying.
I'm
you
not
want him for a year or not? Or do you only want him for the next 3 years if he does A, B, C, and D?
Listen, if he's in by July 1st, he's in compliance. I have no problem with the extension and a raise.
See, and I go down this road too. I started to say this. I don't want it where a circumstance is created where he feels he's got to set up this faux residency for the sake of keeping.
Why do you keep thinking? Why do you keep accusing him?
And at the end of the day, it only makes him look bad.
What makes you think he's going to do that? You're the only one insulting the guy. What makes you think he's not going to do it?
And two, if he didn't establish residency, what would we do? We're going to fire him?
Well, well, John, we know where you're
Seriously,
at. No, we know where you are. We know where you're at. You made sure Dr. Jackson was in Bridgeport, though.
Mr. Chair, John,
so I'm going to entertain a motion to just enter a new agreement.
Mr. Chair, well done. If we're going to do this to Mr. Testani move to Bridgeport, so that's me, all staff. We have staff from Bridgeport School.
Well, that's another question.
They don't live in Bridgeport. So we're going to tell all these.
They didn't sign a contract.
Come to live in Bridgeport, and they got a contract. So all these staff, they don't live in Bridgeport. What's going to happen? We're going to tell them, listen, come on, live in Bridgeport. So you can give education for our staff? Come on, really. Let's keep forward. Leave it to the study the way it is.
All right,
they don't make things go back and forth.
I'm
getting tired. Look at what time it's 9:03, and we don't have nothing done. Come on, really.
Okay, here's what I propose. We'll just We'll take a vote on each of these items. Okay? The first vote will be, I'd seek a motion to enter into a new employment agreement with Michael Testani with a start and end date of July 1, 2021 to June 30, 2024.
How you gonna vote on appointment?
I'm breaking them out
Okay.
individually. And whatever stays, stays, whatever doesn't, doesn't.
I think, John, it's 9 o'clock at night. That's not fair. That's absolutely not fair to this board.
Why is that not fair?
That's a
Each
big
individual
undertaking.
point gets voted on. That's it.
You're corrupt, sir. You're absolutely corrupt.
I'm corrupt.
Yes, sir.
Okay. All right. So,
I'm just a criminal. You're corrupt.
yep, okay. Is there a motion to give a new agreement with a 3-year period starting July 1st?
So moved.
Second,
Okay.
Who
All in
seconded it?
favor?
A roll call vote, please. Who seconded it?
Joe Lombard seconded.
Okay, thank you.
Okay, Mr. Lombard?
Okay, Joseph Halvick,
No.
Albert Benahan,
Yes.
Bobby Brown,
Yes.
Chris Taylor,
No.
Sosimo Fabian,
Yes.
Sybil Allen,
Yes.
John Weldon,
Yes.
Joe Lombard, yes.
Okay. So we've established that. Is there a motion to stipulate in this new agreement that the residency requirement, that Mr. Testani establish residency within 1 year of the beginning of the agreement?
What's the motion to keep it?
That's
in
a
there?
whole nother calendar year.
The motion is that within 1 year of the commencement of this agreement,
What's the
Mr.
commencement
Testani will
date?
establish residency in the city of Bridgeport. Is there a
What's the
motion?
commencement date?
I have a question,
July 1.
though. July 1 of 2021?
Yes, this year.
So July 1 of 20, so June of 2022 is when it'd be.
So by June 30th, 2022.
Oh, John, you're unbelievable.
No,
Now,
no.
You're unbelievable,
No.
John. You should be ashamed
Is
of
there a
yourself.
motion?
You should be ashamed of yourself, John Weldon.
Is there a motion to establish a residency requirement
It's already there.
in the new agreement?
You should be ashamed of yourself, John.
But what are
Is there
the-
or isn't there?
Excuse me, what are the specificities of the new agreement as far as residency is required?
He would have, yeah, and I asked that question earlier. What are you defining as residency? Does he have to register as a voter in Bridgeport? Does he have to register his car?
I would assume so, if he's a resident of Bridgeport. that
You
he
would
has to
assume
vote.
all those things to establish residency.
Yes.
So, is there a
because if he's
motion?
If he's a resident, he certainly votes in Bridgeport. If he pays taxes in Bridgeport, so all of those things,
It comes with all of those things.
yes.
So. Well, is there a motion or not?
For what?
To establish residency within 1 year of the new agreement.
John, why can't it just stay number 2 and he moves in July 2021 like he said he would?
Yeah, don't do the one.
I don't want to get into this back and forth. The question is there a motion to establish residency?
It doesn't
Yes
sound.
or
No, it's
no?
already in there. Why do we have to reestablish it?
Because
It's already
this,
in the
this
contract.
agreement cancels the current agreement. So we're
Why
starting
does it,
anew.
why does
You
it?
want to
why
carry
does it-
this over to the next agreement or not? That's all this is.
Listen, this is very confusing.
Why do we have to have a new agreement? Why can't we just settle on the fact that he's to move into Bridgeport by a special date or a specific date?
I'm down with that. As long as it's July 1st, 2021, I don't have a problem with it.
That's not a part of this agreement. This agreement starts July 1st.
No,
July 2nd.
John, you know what you're doing, John. You know what you're doing. I don't know how you're going to sleep.
Nobody's making a motion. I'm just asking for a motion.
John, you know what you're doing. Come on, cut it out. I mean, be real.
All right, then there hasn't been a motion. I've asked for it a half a dozen times.
listen, John, have the lawyer draft over a contract for us to review, and then we'll vote on a new contract. This is unprofessional. This is crazy.
Yes,
I've really never seen anybody just have a contract out there and you don't get the specificities of the contract.
When this is
and
all
be able
done,
to
we're
read
going to
it.
get a contract. and
No,
show
you're taking a vote.
No.
John, just have Dugas
Oh,
write a new
crying out
contract.
loud.
Let us review it.
But
This
you
is
know,
bad.
Mr.
No, this is
Chairman,
bad business.
So we've gotten as far as a new agreement with a new date.
Never made nor seconded. I would like to make a motion to postpone the rest of this discussion until Mr. Testani establishes residency in the city of Bridgeport.
I'll
Second,
second it.
second.
So we already took a motion that he's getting a new agreement starting July 1 and ending June 30, 2024. That's already been established.
We've never seen the agreement.
We've
though.
never seen, I've never seen anything
Until
to,
he establishes residency.
What?
The-
This has gotten way beyond
Not
complicated.
vote until he
Okay?
establishes residency, and it's been properly seconded.
I got an idea. You already voted on the 3-year deal. I will establish residency by July 1st, 2021. I will
Stop.
be a resident.
Stop.
But
All
then-
right, guys. Hey, John, let him talk. He's a big boy.
Superintendent from agreeing with the rest of the board.
But I'm saying, what are we saying residency is? Because I don't, here's the
Find
thing, I
another
don't,
two.
I don't,
in the woods now. Now you're getting deep into
I
the
don't,
woods.
I'm
John, leave it as
cautioning.
number 2. Whatever number 2 is, he moves in July 21st. Why are you complicating it?
Bona fide
You're
residency
and
complicating
is
becomes
required
a
from-
What's gonna
voter.
happen is you're gonna make him rent an apartment that he doesn't live in.
Stop saying
Like
that.
that.
What is
We're gonna give a
residency?
Bridgeport landlord who
Wait a
contributes to the tax base additional income.
But
He's
all-
taking someone else's
Stop.
rent.
Stop. I'm asking everyone to stop, please. This is embarrassing. It's embarrassing me. It's embarrassing the others who are not involved. Bobby is sitting there quietly. Dr. Fabian, Mr. Lumber, stop. I will establish a residence by July 1st. Leave it at that. We will
Beautiful.
discuss the remaining terms of the contract in the next couple of months. I don't know who wants to sit down with me, but we will discuss the remaining terms. They will include whatever, salary increase, annuity increase, I don't care. We've gotten to this point. Mr. Taylor wants to throw around all kinds of money. I will not accept that kind of money, but I think a fair amount is due.
It was 35,000 extra a year.
See, now we've bribed him to take up residency. That's
Okay.
what you're doing.
Yeah, okay,
Mr. Chair,
John.
there was a
You
motion
wanted to
on
give him
the
a
floor.
stipend? You wanted to give him a stipend, John? Okay.
Yeah, if he's gonna sell his house. and
I don't know
move,
what he's gonna do. Why are you worried about him selling his
Second.
house? You're not a realtor.
Second.
Hold on, point of order, there's a motion on the
The
floor,
vote, I'll take a vote.
properly seconded and needs to be voted on.
Let's vote. Roll call.
I didn't hear what was said.
I said
To
motion to
postpone
adjourn.
additional discussion on implementing this contract until Mr. Testani establishes bona fide residency.
I want the contract begins July 1st. I have until July 1st. So I'd like to have my contract ratified prior to July 1st. I am not going to renege on establishing a residence. If that is the trust factor, if that's where we're at right now, then we got bigger problems than where I live and who's superintendent.
Well, I'm sorry you feel that way, but the contract doesn't start until the board says it starts and.
No problem, Joe. Good. We're good. Obviously, the commitment level toward this administration is not exactly 100%. As Mr. Taylor, this is my point. There has been a level of disrespect. There has been.
I call the question on the motion.
And you know what? This all comes down to the fact that who did what when. This is ridiculous. And I am on the record saying it's ridiculous.
Super T, you're absolutely right, but it's John Weldon that didn't handle it properly, the chairman of the Board of Education. It's not you, it's the
Yeah.
chairman of the board.
Yeah, it's me, Chris.
Absolutely, it's you.
Point of order, there's a motion on the floor.
No,
Let's-
there was,
What's
there
the
was,
motion on the
wait,
floor?
wait a minute. Before Joe, I made a motion to adjourn.
No, you
Second.
did-
All in favor?
No, you did not make a.
No,
motion.
you did
Yes, I
not.
did.
No, you
Yeah.
did not.
We'll go
Oh,
back
you
to
guys
the
are
tape. You don't wanna
unbelievable.
resign,
You guys
no,
are
no, no.
absolutely unbelievable.
We got this on YouTube, you know, and don't let it
I
Yeah.
disappear
know.
like some other videos.
Well, if people weren't screaming over me, they would have heard it. I clearly said it.
We could go back to the timeline. I heard you say.
Go right ahead, Joe. Go right ahead. I have nothing
This
to
is-
hide. I
This
have
is
nothing to prove
unbelievable.
and nothing to hide.
Your,
This is ridiculous. This is
your
absolutely
motion was not
ridiculous.
seconded anyway.
Well,
So
Bobby
it falls
Brown
to the
seconded
floor.
something. Bobby, did you second my motion? You seconded something.
I'm trying to figure out what we were doing. What was the question? What was the motion on the floor?
Oh, so no one heard anybody's motion then. We're back to square one.
So now the
So-
motion was not properly
Mr.
seconded. We
Testani,
got my
Mr.
motion on
Testani,
the
Mr.
floor. That
Testani,
has been
Mr.
properly
Testani, everybody
seconded.
talking at the same
Yes.
time, nobody see their hands up.
It's
You
not
say
this
you're gonna be
conversation.
by yourself, Mr. Testani, because people were gonna come, comment, or you gonna go after you. For the record, as we got 8 board members here, whoever's gonna go after you wanna ask questions, they can come to you because I support you. They're not gonna be, you're not gonna be alone. We got 9 board members, we got 8 board members here that they support you. In that point, everybody agreed that we support you. Any person come after you, tell him they want to speak to Mr. Benham, you can give him my number because I want to be sure I support you. You are not alone in this situation, okay? I just want to put that in the record.
Okay, Mr. Chair, once again, there's a motion on the floor. It's been properly seconded to postpone.
I still haven't
further
heard it.
discussion.
You keep
You
saying
heard
there's
it.
a motion
Oh,
on the
God.
floor properly
Okay, I
seconded.
will say it again.
Because
It's been
there were
properly
8 people
seconded. The
talking at
motion was
once.
all right, stop talking over me and you will hear it. The motion was to postpone the implementation of the contract and further discussion on Mr. Testani's contract until he establishes bona fide residence in the city of Bridgeport, and it was properly seconded by Mr. Taylor.
And Miss Allen.
And,
Well, there's only 1 second.
Well, it's Miss Allen first, but anyway.
okay, thank you.
So,
Can we vote on this motion?
what does that mean as far as what we voted on to extend his contract? What does that mean?
That means the contract
Okay,
extension.
we
does not
already
take into
voted to
place
extend his
until it
contract.
establishes-
No,
We
so it
already
means
voted to give him a new contract.
that's
We
done
took
already.
that vote.
You can't change that.
Can't
That's done.
change that now.
Sure we can. Somebody who voted yes.
Somebody
can
who
make a
voted
motion
for it has to
reconsider.
vote to rescind it.
Somebody who voted for it can make a motion to reconsider.
I'm seeking a motion to
We can-
adjourn. This needs to end. Motion to adjourn.
Second.
All in favor?
Aye.
Opposed?
No. Bye-bye.
Meeting adjourned?